Welcome, friends, to this wonderful session of learning about top 5 Supreme Court judgment on misuse of IPC Section 498A. उससे पहले, let us learn what is Section 498A of IPC. Section 498A of IPC criminalizes husband and his family for committing the act of cruelty, whether it may be physical, mental, or emotional, on the wife in demand of dowry. The punishment for this said offense is imprisonment of 3 years or more, or fine, or both. In recent time, we get to see how women use Section 498A, which is meant for their protection, as a weapon against their husband and his family. As per the NCRB report 2020, out of 1 lakh registered cases, 520 cases were of false allegation, 60,151 51 cases were closed due to mistake of facts, mistake of law, insufficient evidences, or civil dispute. Even various newspaper and media houses have published the news regarding the misuse of Section 498A by married women. Supreme Court has expressed great concern on the growing misuse of Section 498A. Therefore, Supreme Court has issued various verdicts and guidelines through various landmark cases in order to curb the misuse of Section 498A without diminishing its significance in genuine cases. Some of the top Supreme Court judgment on misuse of Section 498A are as follows. Anish Kumar versus State of Bihar, Rajesh Sharma versus State of UP, Social Action Forum for Manav Adhikar and Attorney versus Union of India, Ministry of Law and Justice and others. Khagasan Kaushal versus State of Bihar, P. Shivakumar and others versus State represented by the Deputy Superintendent of Police, etc. Versus State of Bihar. In this case, the wife alleged the husband of dowry under Section 4 of Dowry Prohibition Act 1961. The husband and his family refused all the allegation and sought for anticipatory bail, which got rejected by the Session Court as well as the High Court. Therefore, through special leave petition, they appealed to Supreme Court. Supreme Court, after a thorough observation and investigation, granted them provision bail. They even issued 8 golden principle and direction to guide the arrest of individual under the Section 498A. Rajesh Sharma versus State of UP, the wife filed a complaint against the husband and his family alleging of dowry demand, abuse, mistreatment, and abandonment during pregnancy. The husband and his family argued that the allegations were false. They even asserted that police carried inadequate investigation that led to the harassment of the family. Supreme Court in this case addressed the misuse of Section 498A, and they ordered government to issue guidelines to prevent the misuse of Section 498A by establishing a family welfare committee in each district. The responsibility of the committee was to review the dowry harassment complaint, prepare a report within 1 month, and provide approval for the arrest of the individual under Section 498A. Of Social Action Forum for Manav Adhikar and another versus Union of India, Ministry of Law and Justice and others, a petition was filed under Article 32 seeking where the Family Welfare Committee had the legitimate authority to issue guidelines for the arrest of individual under Section 498A. They even asserted that the social objective of Section 498A has been compromised due to the dilution and increased restriction imposed by the Family Welfare Committee. The Supreme Court stated that Family Welfare Committee was inconsistent with the Code of Criminal Procedure and they were not allowed to issue guidelines for the arrest of individual under Section 498A. In addition to that, they stated that the parties could approach the High Court under Section 482 of Code of Criminal Procedure in order to settle case. They could follow the precedent case of Gyan Singh versus State of Punjab in order to dispose such cases. The fourth case of Khagasan Kausar versus State of Bihar, the wife filed a complaint against the husband and her in-laws for dowry demand and harassment. The charges against the in-laws were dismissed, but the husband was charged under the IPC Section 498A and 322(3). Aggrieved, the wife again filed a FIR for dowry and threats. In response, the husband and the in-laws filed a petition to quash the FIR. But High Court found it that there were some doubtful matters and it needs to be investigated. Therefore, they denied the petition. The aggrieved husband and the in-laws appealed to Supreme Court through special leave petition. The Supreme Court observed that general allegations were filed against the in-laws, and it held that husband relatives cannot be forced to undergo trial in absence of specific allegation of dowry demand. In the case of P. Shivakumar and others was the state represented by the Deputy Superintendent of Police, etc., the husband and his family faced charged under the Section 498A of IPC. The trial court acquitted the husband and his family. Unhappy, the wife appealed to the Madras High Court. Madras High Court convicted the husband, mother-in-law, and father-in-law. The aggrieved husband and his family appealed to the Supreme Court. The counselor from the appellant side argued that the Madras High Court had void and nullified the marriage between the husband and wife, and citing the precedent in Shivacharan Lal Verma was a state of Madhya Pradesh that Section 498A, which requires marriage, could not be rendered as the marriage was null and void. The Supreme Court validated the argument and held that the conviction of a husband and his relative for cruelty of wife under Section 498A of the IPC would not be sustainable when the marriage between the parties to the dispute have been declared null and void. With this, our session got ended. Thank you all. Please subscribe, like, share, and comment.